Hello and welcome to the new series of Drishti IAS. I am Pooja Dwivedi, and in this segment today we are going to discuss the topic Reservation for Marathas. This topic is important from the perspective of prelims and also from the perspective of GS Means Paper 2. So let's begin with the topics of discussion that we are going to look at. First of all, we will talk about why in news. Then we will discuss about the Maratha Quota Law, basically the background of it in brief. We will also talk about Article 342A, which was inserted by the 102nd Amendment Act of 2018. Then we will discuss about the constitutional provisions related to the quota law for Maratha community. We will also discuss about the way forward, and in the last of the segment I am going to ask you a mains based question for answer writing practice. So let's begin with why news. Now, senior advocate while appearing before the Supreme Court has said that when the state government made the Socially and Educationally Backward Class Act to come into being in the year 2018, there was not following of the due process of law. It particularly said that the presidential notification was not there and there was no consultation by the president with the governor of the state when Maratha community was given a quota. So, it of course did not take into account the section or the article 342A of the Indian Constitution. This is what the senior advocate has said before the Supreme Court. First, we need to understand what has happened throughout the years. First, we need to understand about Marathas. So, if we talk about Marathas, they are a community that formulate 32% of the population in Maharashtra. Historically, they have been suggested as warrior caste or landholder castes. So, because of their dependence on the agriculture, and after that, quite a lot distress occurred in the agriculture sector, and because of the division of land, deteriorating quality of the soil and hence the crops, there was a lot of distress that occurred within the community, and that spilled over in the form of protests. And after that, they demanded for quotas and a special class should be made for them. So this is the entire reason for bringing in the Maratha Quota Law. So if we talk about July 9, 2014, the state of Maharashtra promulgated an ordinance granting 16% reservation to the Maratha community. Now, the Bombay High Court or the Mumbai High Court, it stayed this ordinance. After that, a challenge to the stay was appeared about in the Supreme Court, but the Supreme Court also dismissed this interim order on 18 December 2014. The name of the act, which is right now Socially and Educationally Backward Classes Act of 2018. This was before it was Educationally and Socially Backward Classes Act. Alright, keep that in mind. But now it has been reversed, right? Then Maharashtra State Backward Class Commission was made by the state government in the year 2017 and it was chaired by Justice Gaikwad, and he definitely gave some evidence and data was provided for to show that Maratha community, they are socially and educationally backward and they should be given constitutional protection or reservation for them to prosper in the future. And hence, upon the Commission's recommendation, Maharashtra passed the Socially and Educationally Backward Classes Act of 2018 on November 2018. Now, if we talk about the Gaikwad Commission, it said that the Maratha community should be given 12% reservation for educational purposes and 13% for public services, right? But The constitutional validity of the act was challenged before the Bombay High Court, which said that it exceeded the limit of 50% ceiling limit, according to certain pleas, because Gaikwad Commission said that 12% should be given for education and 13% should be given for public services, but the Socially and Educationally Backward Class Act of 2018 said that we are going to provide 16% reservation. And as in the Indira Sohni case of 1992, it was explicitly said by the Supreme Court that the reservation limit should not exceed 50%, but it exceeded 50% limit. And that is why it was challenged. Justice Gaikwad Commission this report was said to be lacking any sort of scientific evidence, and quantifiable or adequate data was also not provided for, which showed that the Marathas are a backward community or they are an oppressed community, right? And it also created a special class of reservation for Marathas outside the OBC class. Because of their involvement outside the OBC class, Maratha has a special class. It of course was in infiltration to the Article 14, 16 and 19 of the Indian Constitution. It was challenging so many articles. That was also the issue with this particular law or act. And it also encroached on judicial power by directly overruling the High Court's 2014 and 2016 orders. Now, it was also said that yes, the Mumbai High Court and the Supreme Court, because of the appearance of this act, they had a stay on those acts. But now, if we talk about the legislation of 2018, the Act of 2018, it overridden the powers of the judiciary. It overdid them. And it was also passed without complying with the procedural requirements mandated by the 102nd Constitution Amendment Act of 2018, which explicitly made it clear that presidential consultation with the governor should occur before classifying any community as socially and educationally backward, which did not happen. So these were the challenges to the issue to the Maratha Quota Law. Now, what did the state government, what did the Maharashtra government say? In its defense, it said that there were extraordinary conditions such as rise in the cases of suicide because of rising indebtedness, and also it said that the provisions of the Act of 2018, the Socially and Educationally Backward Class Act of 2018, it did not override it did not actually infiltrated in the judiciary process, but it just removed the provision on the basis of which the 2014 Act was not accepted by the court. And on 27 June 2019, what did the Mumbai High Court do? What did the Bombay High Court say? It upheld the constitutional validity of the Act, and it said that the state government has all the powers in its hand to exceed the limit of 50% for reservation. This was the first statement. Then it also said that Justice Gaikwad Committee, the report which it produced, it was backed with scientific evidence and adequate data was there to show that yes, there were extraordinary conditions which were allowing for such act to be passed. And the state government did not encroach upon the judicial powers. As I have already mentioned, that the Act of 2018, it did not encroach but just removed those provisions on the basis of which the 2014 Act did not come into being, right? Also, the Act meets the test of reasonable classification under Article 14 of the Constitution. That means Marathas, it identified Marathas as a separate class, and because of that, they are not creating any problem for the other backward castes. So, right equality of there was no infringement upon the right to be treated as an equal. The 102nd Constitution Amendment Act of 2018 does not curtail the legislative competency of the state legislature to give effect to Articles 15 Clause 4 and Article 16 Clause 4 of the Constitution. Right. So what did this statement suggest? It suggested that Article 15 Clause 4 and 16 Clause 4, these basically deal with equality in the sense that the Article 14 would not prohibit the state or the central government in order to make special provisions for such communities which are backward in nature. So, the court said that there was not any sort of clash between these two acts, between these two provisions. And if we talk about right now, Maratha Quota, right now the Supreme Court has actually talked about listening to all those appeals in a hybrid manner. But the Maratha community is extremely saddened and very irate with how the state government made the act come into being. They say if proper judicial process was followed, proper due process of law was followed, it wouldn't have resulted into the present scenario the community is in. Moving on, let's talk about Article 342A. Now, there were certain committees or commissions which were formulated or framed in the 1950s and 70s, the Kaka Kelkar Committee and the Mandal Committee, in order to provide welfare measures and to identify those who have been at the end of the barrel, did not receive any proper or equal support when it came to education and social acceptance. But the 123rd Constitution Amendment Bill, it was passed in the year 2017 and was introduced in the Parliament to safeguard the interest of the backward classes more effectively. Prior to that, if we talk prior to this particular amendment bill, it was in the Indira Sawhney case itself in the year 1992 that the Supreme Court said that we need to create a commission for the backward classes in order to identify which classes actually are backward classes, go to the root cause or the root cause of the problems they are getting into and remove them. So, in pursuance of that, National Commission for Backward Class was created in the year 1993 and it was a statutory body under the Ministry of Social Justice. But if we talk about the bill, this bill wanted to make NCBC not a statutory but give it a constitutional address. That means to make it a constitutional body. So then it basically talked about 123rd Amendment Bill talked about giving constitutional protection or constitutional validity to the body and also have a proper welfare mechanism, right? So it of course talked about many other things. We will discuss them later. And 123rd Constitution Amendment Bill of 2017, it got an acceptance in the year 2018. President's assent and then came into being, this bill came into being as 102nd Amendment Act of 2018. Now 102nd Amendment Act of 2018, it provided for National Commission of Backward Class. We will discuss about it. So under Article 338, NCBC was created with the authority to examine complaints and welfare measures regarding socially and educationally backward classes. Previously, we have already talked about that NCBC was a statutory body. Now, 102nd Amendment Act, not only it gave NCBC a constitutional validity, but also took care of Article 366. Can you please tell me in the comment section what does Article 366 relate to? Alright, moving on, let's talk about the constitutional provisions. Article 340 deals with the need to inter alia identify those socially and educationally backward classes which are in dire need of support when it comes to proving them to be equal with the rest of the citizens, right? And hence, the 102nd Constitutional Amendment Act, it inserted Article 338B and 342A. What does Article 342A say? Article 342A says that the President should consult the governor of a state if there needs to be a classification of certain category of persons to be socially or educationally backward. But to amend the list of those categories, there needs to be a law that should be passed by the Parliament. Keep that in mind. Alright. And I have already asked you about the changes in Article 366. Now, if we talk about the way forward, what is the way forward? First, following the due process of law. Now, due process of law does not only take care of the consequential nature of a law, but also the procedural nature. Consequential in the sense, if certain law makes a person to get deprived of its right to life and liberty. Not just that, but also that the law is fair, it's just for all the citizens. So, first we need to follow the due process of law, respect the constitutional provisions. And merit should also be taken care of along with reservation, because merit is everything when we talk about getting or growing equal. In the sense that yes, certain class of the society, they have been deprived of the rights, but merit should not be compromised. They should be given equal opportunity, but they should not be given equal opportunity at the cost of deserving and meritorious classes. And also curbing political ambitions. Marathas, they play an extremely they have been playing extremely influential role in the political system of Maharashtra, but that should not actually result into regionalism. The sons of the soil theory, which says that the people who belong to certain region should get all the rights available to them at the cost of those people who are alien to the land. So this is sons of the soil theory. Now, if we just keep on burning up the issue as a regional issue, then sons of the soil theory will go for a longer period of time. So, these are the certain way forwards. If you can think more, kindly comment in the comment segment. So, let's move on to our way forward. So, let's move on to our mains-based question. You have to discuss the importance of reservation in striking a balance between social mobility and merit. Kindly write it in 250 words. So, that's it for today. Tomorrow we shall meet again with another segment. Until then, stay updated and thank you so much for watching.